Hello friends, welcome back to our channel Legal Nexus. In today's video, we are going to discuss an important concept under the Indian Contract Act 1872, the contract of guarantee. A contract of guarantee is a special type of contract where a person called the surety promised to discharge the liability of a third person in case that person failed to do so. It is initially involves three parties, the principal debtor, creditor, and the surety. This concept is very significant in commercial transactions, banking, and even day-to-day dealings as it provides security and confidence in financial commitments. In this session, we'll understand its meaning, essentials, and role in legal as well as practical life. Contract of guarantee literally means assurance given by one person to another at the default of some other. It is also known as the contract of suretyship. Definition Section 126 of the Indian Contract Act defines the contract of guarantee is a contract to perform the promise or discharge the liability of third person in case of his fault. The person who gives guarantee is called surety. The person is respect of whose default the guarantee is given is called principal debtor. The person to whom the guarantee is given is called the creditor. The contract of guarantee may be either oral or written. Essentials of the contract of guarantee. A contract of guarantee may be oral or in writing and must satisfy the condition under section 10 of the Indian Contract Act. There must be three parties, namely principal debtor, surety, and creditor. The expression principal debtor in a contract of guarantee or suretyship, one person agrees to answer for some liabilities of another to a third party. It is therefore obvious that there must be a principal debtor. There can be no contract of guarantee unless and until there is a principal debt consideration. According to Section 127 of the Indian Contract Act 1872, anything done or any promise made for the benefit of principal debtor may be a sufficient consideration to the surety for giving the guarantee. It may be oral or writing and must satisfy the condition under Section 10 of the Indian Contract Act 1872. There must be three parties, namely principal debtor, surety, and the creditor. To simplify this principle, for example, A sells and delivers goods to B. C afterwards requests A to forbear to sue B for the debt for a year and promises that if he does so, C will pay for them in default of payment by B. A agrees to forbear as requested. This is a sufficient consideration for C's promise. Guarantee for minor's debt. A debt contracted by a minor is not binding on him. In case he fails to repay the loan, the creditor cannot enforce the promise through a court of law. It is because the minor's contract is ab initio void. If a person who is competent to contract gives a guarantee for such a loan, the creditor cannot claim money from the guarantor in the event of failure on the part of the minor. It is because there is, in fact, no principal debt recoverable through court of law. In the famous case Court and Company versus Brown Leckie 1 KP 106, the English court held that if a guarantee has been given for a debt contracted by a minor, the surety is not liable. In England, a loan made by a bank to an infant is void under Section 1 of the Infants Relief Act 1874. Thus, there is no recoverable debt. Thus, guarantor of such loan, if the fact of infancy is known to all parties, cannot be made liable in an action on the guarantee. Surety or guarantor. Surety is also known as guarantor. Surety is one of the three parties in a contract of guarantee. The expression guarantee literally means assurance given by one person to another at the default of some other. Is it also known as contract of suretyship. Section 126 of the Indian Contract Act defines the contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of default. Surety's liability. Section 128 of the Indian Contract Act deals with the nature and extent of surety's liability. The liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. To simplify, a guarantee is to be the payment of a bill of exchange by C, the acceptor. The bill is dishonored by C. A is liable not only for the amount for the bill but also for the interest and charges which may have become due on it. In conclusion, the contract of guarantee play a vital role in ensuring trust and security in financial and business transactions by involving three parties, the principal debtor, the creditor, and the surety. It creates a legal safeguard for repayment and performance of obligation. Understanding this concept not only help in legal studies but also in practical life, especially in areas like loans, credit, and business dealings. Stay tuned to our channel for more legal topics. If you found this video helpful, don't forget to like, share, and subscribe.